It is 1:02 p.m. and calling to order. I think we will start with roll call or introductions and roll call. I'm Rachel Sprague. I am the chair. I'm calling in from Lanai. Jay?
Aloha, I'm Jay Stone.
Do we ask folks to say where they're calling in from, and do we still ask if there are folks in the room with them?
Yes, because this is a sunshine meeting. So
Right, so I'm calling from my office. There's no one else with me, just me.
Thanks, Jay. Dawn?
Hi, Dawn Hager Nordblom. I'm alone in my office except for my dog, and I'm calling in from Maui.
Excellent. Thanks. And Michelle?
Michelle Lefebvre in Hilo from my home office, and I'm alone.
Thank you. And then introductions of looks like there's a number of folks in the staff room.
yeah, yep. Okay. So the staff includes myself, Mary Alice Evans, Tom Eisen.
Senior planner here in the environmental review program, and we've shifted to holding this meeting in our room as opposed to the previous Zoom meetings. We're on the 6th floor where the rest of the Office of Planning and Sustainable Development is. We just set up our system here, so this is the maiden voyage.
Okay, and then Jennifer Ching, who is our administrative assistant for the environmental review program. And I'll have Tom and Jennifer introduce our two interns. Yeah, this is Christine, and Mickey. How about a little bit of background from both of our interns?
Oh, I just graduated from UH Manoa in December. Yeah.
Great. What was your major?
I majored in environmental management.
Wonderful. All right. And Mickey, how about you?
Yeah, I went to Hawaii Pacific University for environmental science, and then I'm also going to UH, graduating in May with a degree in pest pathogens and invasive species.
Wow. All right. Thank you very much, both of you.
And they're helping out here with a lot of database management projects.
We're very fortunate.
That's wonderful.
Yeah, fortunate to have student interns. I'm a huge fan of interns. Over to you, Chair.
Thank you. And is the ERP account that's also in, is that just you in a different?
It's being organized and kind of the Zoom meeting is being recorded and managed by another staff. That's what the other participant is, but it's
okay.
Rachel, that's
Kim
Ishimoto.
Oh, wonderful.
And she is, she's not sitting out here with us. She's in her cubicle, but managing the Zoom account.
Totally awesome. Just wanted to make sure I wasn't missing anyone. Thank you for managing the Zoom account and taking notes. We really appreciate it. So let's go into the agenda. So the first item, we do have quorum. All 4 members are here. And the first item is the review and adoption of minutes from January 7th, 2025. Did anyone have any corrections or questions about them?
I did not.
Thank you. I'm seeing not shaking heads. So if given not, I'll entertain a motion to adopt the minutes from January 7th.
Second. Oh, sorry, Michelle.
I'll moved and seconded. All those in favor, please raise your hands. Counting, and that is unanimous from the council members, so that passes. So the next item on the agenda, now I'm realizing that Mary Alice and I chatted about some items to talk about, and I neglected to include a chair's report. So hopefully, or a director's report rather. So hopefully these will capture the items you needed to talk about. If not, Mary Alice, I apologize, and we will bring up other things next time if we need to. But so the first item that we wanted to talk about was the Environmental Council rules revisions slash amendments. This is what we've talked about before, is that we've revised our internal policies and procedures, but there are still some language, as I understand it, in the statute or in the regulations that need updating, and perhaps Mary Alice can describe what that is and had a potential suggestion for a way forward that she was hoping the council could think about and talk with her about.
Yeah, so Act 152, 152,
Yes.
Session Laws of Hawaii 2021, which transferred the former Office of Environmental Quality Control from the Department of Health to the Office of Planning and Sustainable Development, made some changes both to the council's duties and responsibilities, and of course the housekeeping changes to the, because of the transfer from one department to another. And that would require rule amendments that would update the rules to match the new statutory language. And there, as you guys know, there are two statutes that, one is Chapter 341, which establishes the council and outlines your duties and responsibilities and powers. And the other is Chapter 343, which is the chapter that does all of the statutory process and purpose and other statutory obligations for any state or county agency or applicant that wants to accomplish a project that has a trigger for an environmental review process, whether it's an exemption, an environmental assessment, or environmental impact statement. And so I think most of the changes are in Chapter 341. And is that correct, Tom?
There are some changes to well, the rules.
Statute. No,
But
343.
statute, well, it's correct. The 343 talked about the process.
Right.
And 341 is what establishes the council
Right.
at this
So
point.
are there any changes that have to take place in 343 as a result of the transfer? Okay, so you're looking at just Chapter 341. It outlines a new process for adopting rules, and that is the Director of the Office of Planning and Sustainable Development, which under the Act replaced the Executive Director of the Office of Environmental Quality Control, will consult with the council on any proposed rule adoptions. So, and then we follow the chapter 92 or 91, I think, process for rule adoptions, which means we then post them, send them up to the governor for approval to take them out to public hearing, hold a public hearing, and then pending, if there are no substantive changes, request governor's approval to adopt the rules. So to get that off to a good start, I would like to be able to work with the council members to figure out the wording for the changes to the rules that apply to Chapter 341, and make sure that they conform with the new statutory language. So I would leave it up to the chair and the members to decide how they want to proceed with that. Do they want to form a PIG? Do they want to proceed as a committee of the whole and discuss? I think what we could do on our end would be to provide a draft to the council members so that they could something to start from and look at. We start with the rules for chapter 341. Are there rules?
Yeah, the council has rules 11-2.
No.
201. Separate, yeah, there's
Separate.
separate rules from these
Okay,
rules.
I have to admit, I haven't looked at those carefully. Anyway, that's what, we could do that, and then if you, are willing to, we have to consult with you, so you have no choice.
Yeah, what do folks think about well, yeah, I guess do any folks have reflections on that in terms of if the council wants to take it up first, or if we would welcome and appreciate the staff going through and doing a first pass identifying areas that need revising and or updating, and then coming to us with at least identifying those areas, if not potentially proposing suggested changes. Dawn?
So strange. I raised my hand and my computer's like, oh, you're raising your hand. It's a little scary with AI. Anyway,
Oh my God.
I was like, what's going on? My computer rebooted. I would prefer that CBED does the first revision with their AG's review, if that's possible, and then we come in second. That way we're not blindly stabbing at rules that we might change, on our end. That's my thought.
Thank you. Michelle?
Yeah, and I think the council had done, the rules committee had done a bit of work at this. I know Onauna had thought quite deeply in the rules committee about, the rules, in 341 and 343 that they had recommendations, to update. So does ERP have those, have that list from Onauna, from the rules committee?
We could look for it. I don't
recall.
Okay, just, I mean, I definitely support ERP taking the lead, but might as well build off the work that Onauna had done already. So if you guys don't have it, I can ask, or Rachel can ask her for that, but I know that they had done quite a bit of thinking about this.
Yeah, I believe Onauna shared I think she shared a location where her files were. If staff all doesn't have it, I think we can go looking and see if we can find that. But it seems Jay, does that sound like a reasonable approach to you as well?
Yes.
Yeah. So I think we are all, I don't know that we need to motion. But it sounds we are all in seems in pretty strong agreement that that we would appreciate the staff going ahead and looking at those rules. We will go back and see if we can find information from Onauna on what the rules committee had. I don't think they drafted language necessarily, but there may have been some notes that would be helpful in if they were thinking. But otherwise, I think it would be save a lot of time. You're very familiar with them and know where to start, and then we can have conversation about what the changes are and if we have any suggested modifications to those as it goes forward. That would be very helpful, and we would appreciate your work on that.
So it's a two-step process, right? We're gonna ask Onauna for the minutes or her thoughts, and then we're gonna give them to OPSD ERP, and then they're gonna take a stab at it with their internal staff, and then it'll come back to us. So that'll be the fourth step. And we'll look at the rules, proposed rules changes. And then I know Mary Alice that rule changes are a lot more than that on the administrative side. So I think there is an administrative process outlined, right, for rules, where we have to send it to all the legislative bureau, et cetera, et cetera.
No, that's after the rules have been adopted.
Okay.
And then It is up to the departments to make a determination if a proposed rule change would impact small business. And if it doesn't, then you don't have to send the proposed rules to the Small Business Regulatory Review Board. And I think that's probably a point of discussion. I think the rule changes may only impact the council because I don't think it changes the any of the triggers for whether you are subject to 343 or yeah, we'll take on that question with the AG, and if the process doesn't appear to affect small businesses, then we'll have a slightly faster process.
Okay, that's helpful. Are there any other thoughts or questions from the council on that item? Mary Alice, is there anything else from you or Tom on that, or seems pretty straightforward?
Yeah, the devil's in the details of just doing the work, but the process is relatively laid out.
Let me Chair, may I kind of maybe for Jay's awareness, back in when the former Office of Environmental Quality Control and the Environmental Council transferred over to OPSD, it had very detailed bylaws for the council that were drafted probably 30 years ago. And in talking to the council members and the chair at that time, I made a recommendation that instead of having bylaws, which are not required for state boards and commissions, members can decide to have them, but they aren't required to have them. I suggested doing policies and procedures for just the council's process items. And I think a draft was done of that in 22. And I'm not sure, I think I may have a copy of that.
I don't. Les would have been involved with that, and maybe maybe to work with you.
They're attached with the meeting minutes, so we can probably find them with the minutes.
That was the chapter 201.
I think the advantage of policies and procedures for things that are not don't require rules are that they are more flexible and that the whole council can adopt or amend them without having to go through a year-long process. So we'll try to find those.
Yeah, are they not on the website? I know that I'm pretty sure we approved them in like May or June of last year. I see it. We had final edits due no later than April 26th. I'm
okay. All right.
Looking through it's my recollection that we approved policies and procedures that we had worked on, in fact, for like 2 years, that covered the council itself, and the committees and the council itself. And then, but there was still that bigger picture rules change that needed. So those policies and procedures would also be a good reference point because that was already approved by the council, and effectively, if we could make the rules consistent with those policies and procedures, that's maybe a little backwards way of doing it, but that's what we did. So, yeah.
Well, thank you for finding that and refreshing my memory on it. Okay, I appreciate that.
Yeah, we might just need to, it wasn't earlier than May 2024. That would have been the earliest that we approved them, but it could have been the following meeting. I can't quite remember.
Okay.
Yeah. So, okay. So it seems like that item is all good. We have a way forward. Nothing to take official action on right now. Um, Tom and Mary Alice, let us know if we can help. We will look for in Onauna's files if there's any rules that would documents that would be useful, and we will send them your way.
Thank you.
Great. So the next item is one that it was brought to our attention that there are, or were, at least at the time of agenda creation, a number of bills proposing to amend Chapter 343 in different ways, in particular in regards to state agency permitting. And I am guessing that Mary Alice has potentially an update on which ones of those are still live and which ones of those the department would like, or OPSD would like our input or thoughts on.
Yes, thank you, Chair. I think one of them is still alive.
Just one.
And what's the bill number, Tom?
SB 1047.
So a little bit of background, which I think Don is probably the most familiar with because it involves Maui. And that is after the success of opponents of the aquarium collectors licenses being challenged by opponents of that particular industry as not having, as DLNR not having complied with Chapter 343 prior to issuing those permits or renewing the permits. So some of them have been around for quite a long time. And the court in the Umberger decision said that DLNR needed to comply with 343 and provided 3 tests for whether they had complied in terms of an exemption if those permitting program was eligible for an exemption. If the department determined it was, they had to provide information on 3 tests. Well, opponents of another set of permits by DLNR for the were challenged in court as well. And that was the Kaanapali commercial boating licenses. And the Maui Judge Peter Cahill remanded that back to DLNR to determine whether that permitting program was also subject to 343. And the department has told the legislature that they will definitely comply, but they need more time. The boaters were deeply concerned that their license to do business would not be renewed and they would lose their business. And so they went to the legislature with a bill that would allow DLNR to renew their licenses. These are 1-year licenses, so they would all expire within, within a 12-month period. While DLNR pursued complying with 343. And so that bill has been making its way through the legislature. And it has been, Tom and I have been going and providing testimony in support of a fairly narrow approach. The Senate Judiciary Committee made a number of amendments that limited that extension of those licenses, they limited it to 1 year extension, so it gave DLNR a very, a short window to comply. And it said only currently permitted licensees could be extended. And DLNR has been very careful to explain that the aquarium collectors' licenses have all expired, and they would not be affected at all by this bill because they don't have current licenses. Only currently permitted licensees could avail themselves of this temporary relief. I think the larger issue that I see is that this is an area that for decades was not considered subject to 343, which is permitting programs, as opposed to development proposals that have use state or county land or state or county money and generally involve land disturbance and building of structures and have more of a physical permanent impact on Hawaii's environmental resources. Now, what DLNR has said is they will not make the licensees each do an environmental impact statement. They have told the legislature that the department will do it for the entire permitting program, but they have a number of different permitting programs. And so they're looking at the cost and economic disruption of needing to do this for all of their permitting programs. Eventually, should there be challenges to other of their permitting programs, or I guess you'd say, yeah. So it opens up for the council, I think, to discuss and consider, whether this was a stretch on the part of opponents of a particular industry, or whether that was an appropriate, because it does involve, this involves both the land side, shore side, harbor facilities, and the nearshore waters, clearly the conservation district. And of course the harbor itself has had, complied with, whenever they've made changes, have complied with 343 for construction and maintenance activities, probably the maintenance activities under exemptions, but not the program. So I'm wondering, Chair, what you and your members think about this approach, this kind of legal expansion of 343 to cover things that weren't heretofore considered as being subject to. I mean, I say that because these permitting programs have all been in place for decades, and up until they were challenged in court, nobody assumed that they were subject to 343. So what do you think? Oh, you're muted, Rachel.
Apologies, Dawn. Yeah, I was just gonna say, Dawn, go ahead.
I was gonna say this. I'm not so sure we should comment on it until the ledge makes a decision, right? Because to me, I feel like this is a public meeting, and if this comes before us in any shape or form, I don't want this meeting to be coming back and reflecting poorly on us, as we're just commenting on it. So that would be my position, is just to see what happens with ledge before making any comments at all, because I feel like it's going to come to us at some point, and I don't want to have somebody say, well, you said this in the meeting, and and it may never come before us, but I feel like, I don't, I feel I'll say this, I'll feel very badly for the voters and the businesses, and the fact that, a document in EIS, EA should have been talked about 5 years ago when this was happening. I don't think it's fair to have to scramble to do a report because now, personal finances or business finances are on the line. So I think it is unfair, in that sense where, there could have been, I feel like, a little bit more support, on some sides without calling out the sides.
I would also agree on holding off. I know professionally, my firm was approached by one of the operators, so I'm not sure if that's a conflict also to comment on it. We're not doing work. We're not under contract to do that work, but yeah, I would want to see, how things play out, I guess, and then if needed, if I have to recuse myself. I mean, again, we're not under contract. I'm not sure how that part works, but. Just want to disclose that now.
So can I ask, and this might be a question for staff of for Tom or Mary Alice, so is that one of the major differences between Chapter 343 and NEPA, where NEPA is pretty clear that the triggers for NEPA are federal agency funding, carrying out or permitting an action, and it's then their responsibility technically to make sure that if they're permitting something that NEPA is being complied with. There's also a fair amount of options for, exemptions, the categorical exclusions and that kind of thing. So is
land or money, right? It can be, if it's physically on federally owned land, that's also a NEPA trigger.
Oh, sure. Or if it's on, yeah, but then
funding or
also yeah, but like they do NEPA on it, like every endangered species permit, or under like categorical exclusions, that kind of thing that they've already assessed that are programmatic. So is that a difference? Does 343 not currently address explicitly agency or state permitted activities?
The way I look at this whole thing, with one lens I look at this, it's almost this metaphysical existential question of what is a use? Because there's these triggers in 346, the use of state lands. And heretofore, this was not considered a use. These activities were not considered a use, but a court has determined, I don't even know if they've determined it's a use, but they say 343 has to be done. Whether or not it is a use is a different question, maybe. But for applicant actions, they need both a trigger, like the use of conservation district lands, and they need a permit. So the fact that these operations need a permit is like half of the test. And the other half is, did they hit a trigger? Well, depending how you define the use of state lands, they did. Apparently now they did. In the past, people would say, no, they didn't. Well, that's where the court has weighed in and said that. And I don't know if the court actually said it is defined as a use, but it just says you have to do 343. So maybe sidestep that. And I made a mistake earlier when I referenced the bill. It's actually my dyslexia kicked in. SB 1074. 1074. I think I said 47.
So Rachel and Dawn and Michelle,
Yeah.
sent the three of you. I keep a spreadsheet list of relevant, well, not relevant, I shouldn't say relevant, of bills, House bills or Senate bills that I think we may want to take a look at. And that's the first one on the list of that spreadsheet, right? So I use a tracking software called fastdemocracy.com. Allows me to find these types of bills relatively quickly and where their status is. So I think that's the one that Tom was talking about. There's a companion bill, even though it doesn't say so, House Bill 661.
That actually was a little bit different.
Yeah.
And we were tracking
Is it-
both of them. They were a little different. That one has died, 661. Some of the aspects of that were brought and included into the current House draft of
Yeah.
the Senate side bill. But there were a number of bills all dealing with the same issue in different ways.
If you go to that, there in the spreadsheet, there's a hyperlink. If you click that hyperlink, you go to fastdemocracy.com. It's a free service. You can pay for it if you want, but for the purposes I use it for, it's free, and you can get to the latest version of the bill of whatever you're trying to look for.
And we usually use the legislative webpage for that because it's pretty good. Rachel, back to your question about the difference between NEPA and HEPA. I don't think HEPA uses the word permits or permitting as a trigger, but
It's not a trigger, it's a required thing for an applicant action to have in addition to it.
But it occurs after compliance with 343 rather than concurrently.
Well, actually, it's part of the test of getting in. You wouldn't have to do 343 if you're an applicant, if you didn't need a permit in addition to hitting the trigger.
Yeah.
But the permit follows.
Yeah.
343 analysis.
It used to be the permit was either a zoning change or a building permit or a grading permit or something that related to a physical change in the environment, or physical impact on the environment. What we heard in the testimony that worried me was, and it relates to what you asked, Rachel, is that some of the testifiers believe that that Chapter 343 could approve or disapprove projects. They weren't aware that 343 is a disclosure process and that it provides information on environmental impacts and possible mitigations to decision makers who then subsequently use that in making decisions about permits and other land use requirements, and possibly licenses and right of entries if you're thinking DLNR. And I'm thinking that one of the things the council might help with is trying to restart some public education forums around that difference. I don't know if that'll help because, you know, folks tend to come out for controversial things, but not necessarily for educational things or events. But we in listening to what seemed like hours of testimony on these measures, a lot of times folks thought that if there was an amendment to either 200, the permitting chapter for DLNR, or 343, that it would somehow it eliminated environmental protections rather than allowing a legally permitted activity to continue for a very temporary period of time. It was instead of that, you know, those gray areas of nuance, it was very much a all or nothing kind of discussion, which I think happens when people kind of believe that they are one way or the other. They're either saving people's and families' livelihoods or saving the planet. Instead of
And in NEPA, those conditions, those mitigation measures that you develop as part of, what's written into a record of decision for a NEPA document. Yeah, as Mary Alice explained, those are not commitments in the same sense. So when a record of decision is signed, the person, whatever agency is conducting that action, or if it's a private entity, if it's kind of an applicant action on the NEPA side, they are committed legally to those mitigation measures in the record of decision. As Mary Alice said, any of those that come out of a HEPA document are for consideration for that approving agency to wrap into whatever permit they're issuing. So there is that distinction in HEPA versus NEPA, and sounding like the public was seeing it more of the way NEPA does, even though we were in the sort of HEPA realm. So that, yeah, an acceptance of a disclosure, document on the HEPA side does not equal authorization to do it. It's a step in the process.
That actually is super helpful.
A lot of the people knew this, but they were just enhancing their perspective and their arguments by using information that they picked and chose for that argument.
It's human nature.
I'd say it's the hardest part of public outreach on any EA or EIS that we do is to explain where we are in the process when they like to use an EA or an EIS as a referendum on a larger process, be it zoning, be it, some other kind of permitting, right? They're there to sort of, they're upset about, a bigger issue that the EA or the EIS can't solve. And then when I'm in that role, then it's, you're just there to listen and explain the best you can. But yeah, all the same frustration. People feel frustrated that they can't, affect the change that they want because they're in the wrong box at that time. That's hard.
I'll go to your comment. Sorry, can I talk, Rachel? Is that okay? Okay, sorry. Mary Alice, I'll go to your comment about the public information meeting. So, there was a project recently before the Maui Planning Commission for a housing project, and the Planning Commission thought the EIS was not sufficient and this was very recent. And, if I were to have a public meeting, it would be very difficult, I think, because it'd either be Tom, for 45 minutes talking. I could ask Albert Perez from Maui Tomorrow if he would be interested in talking to the projects that they see as potential, understandings of the EIS, because basically everyone uses an EA or EIS as a decision-making tool for the agency, but sometimes, public opinion is not understanding really what the document is, like you said. So I'm not sure we'd be able to change anyone's mind in a public forum, but I can certainly pull together a bunch of people to see if they're willing to talk about it, but I'm not so sure not a law firm, maybe a law firm, maybe Alnona. But I'm not sure a planning firm would want to put themselves in a crosshair of that forum. It'd probably be more of a nonprofit or, Rachel, people who actually do educational projects, not affordable housing that's on such a hot plate right now.
But I get what you're saying, Dawn. It's and to your point, Michelle, that it's there. It could be useful at some point to have forums about sort of the role of HEPA. Like we've ended up in things where there was a question in front of the Lanai Planning Commission about whether a certain thing was a conforming use for county zoning, and they were wanting to call for an EIS just because, and that was what they ended up taking action on, and it was well, that's not the question, and that wasn't it was private funds on private land, and it was just asking for I can't remember the terminology. It was just asking for acknowledgement that it was a use that was within the existing zoning, and it's well, that's not. It was wanting to use an EA or in this case an EIS as a sort of as a referendum or as a way to And it's like, well, that, yeah, it wasn't something, it wasn't wastewater, and it wasn't something that was otherwise a trigger for HEPA. So I don't know, Mary Alice, I'm not sure if this is a helpful conversation that we've been having, or if there are any specific questions we might be able to help with. I kind of get, I definitely acknowledge where Dawn is. I think that perspective is really helpful to think about, that we're not necessarily, some of us are, some of y'all are subject matter experts in chapter 343. I am not. But so the council has some expertise, but is not really a body of expertise on that topic, and it might be better in the legislative process for us to not weigh in, but I don't know where the politics are around that.
You're talking about the EIS, right? The bill going forward right now.
Yeah, sorry, I was circling back to the bill the bill that's going forward.
SB 1074.
Well, I think we're past the point where anybody's putting testimony in. Well, actually, I take that back. I've got to leave in a few minutes to put testimony in on a transitory development bill. But we're at the last point of hearings on bills before they dissolve the subject matter committees and establish conference committees on those bills that have passed in both the House and Senate with different versions. And then they will start holding conference committees in a week or two, and be done by May 1st or sooner.
But they do not take testimony, correct?
No, they don't take testimony, but they are private. I saw that in the paper this morning, and I thought, for somebody, no, conference committees are open to the public. In fact, I go to a lot of them, and, just to see how the thinking is evolving or not on bills that we're interested in. But no, I think wasn't thinking so much about testimony on this particular bill, more about the general trend of expanding what the courts, in response to opponents of projects, expanding the scope of what's considered a trigger, a use, something that didn't used to be considered subject to 343, and now, thanks to court orders, is. And I do remember, I think some of you remember Coral Ridge on Oahu. Private land, private money, but they ran a wastewater transmission pipe under a state highway. And opponents of the development went to court and said that the development should have been subject to 343 because the wastewater transmission pipe crossed under a state highway, and therefore was the entire development with all 1,100 homes or whatever, and should be subject to 343, and the court ruled that it was, and they did an enormous EIS, and it took about 10 years to get the actual approvals from the city council, not for the development to proceed, and it is now going forward and building homes. So I'm seeing a kind of an expansion of the applicability of 343, and I think that's something that we should be watching with interest, not necessarily with not disapproval or approval necessarily, but just how is that affecting the ability of decision makers to have good information at their disposal when they make decisions.
And how AGs will respond from these agencies to the or to these legal right decisions from from courts to do this. I mean, in the end, right, it's a legal vulnerability for the agency to consider.
Yes.
I don't know if you guys heard about that new book Abundance that's out. It's a little, so it's only related to this, but heard a review of this book Abundance, and it's interesting take on how well part of the argument is how nationally right housing is a good example or as an example they highlight in the book about how environmental laws can be sometimes used by the opposition to sort of stall what often communities can need, not necessarily for the, I wouldn't say the right reasons, but for not wanting the project right to happen, some sort of NIMBYism creating to a lack of abundance. So anyway, it's an interesting connection. If you haven't heard about it, check out Abundance.
I'll be very honest, I appreciate the fact that we do have environmentalists and activists, because, I think there is some, if you look at some of the videos on Maui and, I think that some parts of, Hawaii needs to be protected. And that's what 343 is about. And that's why we're living here. And we want to protect our environment and what we have. And I think at the end of the day, I appreciate people, and I've always said I DLNR too. I appreciate those people who come and testify in opposition to DLNR, because I think it leads a more balanced voice. Not necessarily they'll get what they want or DLNR will get what they want, but I think it leads to show really how maybe out of touch we may be to the requirements of people who live in Hawaii in general.
If I could say something related to the prior question of whether or not we feel we should comment. My feeling is should we or shouldn't we? I think we should. It's a matter of how we are going to comment. I don't understand how the council functions well enough to understand if we need to do it as a body or if the individual members can make their own comments related to the legislation, right, that's being proposed. So my thinking is that if we're going, if either as a body together or a committee, a subcommittee, or as individual members, that the response should be in relation to the specific legislation that's going through the approval process now, the review and approval process through our legislature, and not necessarily comment on an expansion of the application of 343 necessarily. And then that would be, I think, in my opinion, better served in terms of what our function is as a council, if we focus on what that legislation is saying versus a deeper history of how it got to that point, how the solution came about, or what the impetus or reasons for the legislation. Because I think then that would narrow our response, and I think would be more appropriate in terms of what the council's actual function is.
In the past, the council, just given the structure, how often it meets, how the legislature works, it's been a challenge for the council to respond to bills because so much happens between the time that the council can meet to deal with it. And so I know that there have been times where individual members just testify as individuals because they're interested. They don't feel they have the authority to represent the council because the council didn't have a chance to coalesce around a perspective, specific testimony to give on a bill. It's a challenge for a body that only meets as often as you do.
Thank you, Tom. That's helpful background for me. I appreciate that.
So, I'm not sure. I think that was very helpful for me in terms of conversation. I'm not sure that we came to any really stronger identifiable conclusions. Um,
Well, I think, Rachel, what I heard was
yeah,
individual members can make comment as individual members of the council, but not as the council, as just
yes.
people, right?
Mhm.
That's what I just heard.
Mhm.
And then I think if we, as a council, decide to, then that's a different situation, right? It sounds like it to me, that the council would then, we'd have to meet and make a discussion or discuss that, and then figure out how we would want to respond as a council. But I understand what
Yeah,
Tom is
if
saying.
we were to make a public statement, yeah.
Yeah, yeah. What Tom is saying, that just the practicality of being able to do that, the way our council operates, is difficult or challenging, I should say. I didn't say difficult. It's challenging.
So it might be easier for the council to, as opposed to taking on individual pieces of legislation that move through this rocket fast pace, take on the bigger issue of how the application of 343 is evolving over time. And just, yeah, what's the positives or negatives or things to consider, implications of this parent trend.
Good, and that makes me, your comment, Tom, makes me rethink of how we would approach this versus looking at the specific legislation, just from a practicality point of view.
Yeah, I think for me, I think that makes it a little bit easier to get one's hands around, or one's wrap one's head around, in terms of thinking about like where the council could be useful. It also potentially avoids that just sort of awkward interface of a advisory state advisory council weighing in specifically on legislation, but that question, generally speaking, around the application of 343 within the state and within different kinds of activities and uses, or where it fits into permits. I don't know, Don or Michelle, does that sound like something that is a forum, or does that sound like that's something that's sort of discussion, or do you want there to be more than 4 of us on the council to try to tackle that?
You talking about the bill still, or are we talking about the rule?
No, the idea, the overall sort of like what I think what Tom was just stating, which I think, again, please correct me if I'm misstating it, of sort of the role of 343 in the state when it comes to the applications of it.
I have 2 thoughts. One is, let's be trailblazers, the 4 of us. As long as we get confirmed on Friday, right, Jay?
There's
And I don't know if there's other people who are also potentially going to be on the committee. I don't know if there's other GM bills on Friday for environmental advisory. No. So then, Mary Alice, how long would it take to actually really get, more members on the board or on the EAC? Months, 6 months?
If we had applicants, it shouldn't take long. Well, during a ledge session, from opening day to adjournment, the governor cannot appoint interim members. He can nominate. And those people, the nominees, if confirmed, can start serving from the date of their floor vote, their full floor vote. But since we're right at we're past the deadline that the ledge is set for introduction of new governor's messages for appointees, nominees. And yet we aren't at the end of the session. I would say, Dawn, that if we have applicants, probably Gov's office would wait to make an interim appointment after May 2nd.
So I guess it would be wait until after May 2nd to see if there's any other people who might join us or be trailblazers. Only thing I don't want is we get new members and then those members are like, oh, we wish we had a voice in the process, or you should have waited for us, you know? Yeah. So.
We have been checking to see if there are applicants, and so far there haven't been, so I'm not sure we have potential interim appointments lined up waiting for, you know, the day after the adjournment of the legislation.
Got it.
Well, we're doing a lot. We're gonna do those rules and then this other part. Will we have the interns to help us?
Here we are.
I have next week.
Yeah, she has next week.
They're both fairly short term.
Yeah, these internships aren't they, how long are they?
They're only, first appointment is I think 3 months, and then the second one is another 3 months, so 6 months max.
Yeah, so this is a fabulous program that the legislature started by funding Department of Labor and Industrial Relations to set up what's called the Hale Imua internship program, but it is a limited term internship.
6 months max, and they're both into it a ways.
Yeah. And have, you know, are working on updating our databases. We have assignments. I'm gonna have to leave soon for a hearing, a finance committee hearing, in which we do have testimony, not on any bill relating to the Environmental Advisory Council or 343, a transitory development bill. So,
I wanted to say something. Mary Alice, thank you for putting in testimony on my behalf. I appreciate it.
oh, you're welcome. Thank you for being willing to serve. And same to Jay. Thank you very much.
Yeah, this is sort of jumping to the next one, but they are both yeah, they're is that the confirmation hearing or it's the hearing in front of the committee?
It's
I
the
think
subject matter committee hearing, which reaches a decision on advice and consent to the full Senate.
Yes.
And then the Senate will then schedule a floor vote before the end of session, in which the full Senate will vote on nominations, all nominations, whether they get a subject matter committee hearing or not.
Yes, so that subject matter committee hearing is April 4th, which is Friday.
Yes.
Yeah, for Dawn and Jay.
Yep.
Yes.
We're very excited. So I guess I'm a little bit at a loss in terms of like what would be if the next step is us thinking about ways that it would be useful or thinking about people that would be useful to bring in to have a discussion or forum. Otherwise, yeah, I'm not necessarily sure what is the best route forward or if there's action that we can take or rather action to move towards on that sort of overarching 343 question.
We couldn't think over it. Oh, sorry, go ahead.
Oh, sorry. My first reaction, and no, Rachel, is I like the idea of a forum and educational opportunity for people to understand the 343 process and how it's historically been applied, and then how the recent decisions may have influenced the current or future applicability, and then the legislation towards that. I think that would be really informative for people. I'd be interested in that. I wouldn't say I'm not a 343 expert, but I do those quite a bit with the rest of our staff in our company, and we do have to address those kind of things. If the one tidbit I'd like to add though is if you use certain AI software, it will actually tell you that the final document is an authorization of the action under HIPAA.
Oh,
Under HIPAA, right? So if you try to use AI software, because we have incorporated AI software into our company's processes, right? And we use it for various things, very simple things and much more complex things. You will get, because I just did it during the earlier conversation. I typed in what does the record of decision authorize the action under NEPA, and I did a similar question for HIPAA, and I got the same answer, right? So depending on how people are searching for information and what tools they're using, right? They maybe, I mean, they're only going to be able to understand what they see, right, and what they read. So I think an educational form would be very useful, because then that could try to not dispel, but it would help people understand what the actual process is about and how that moves forward, because there are distinct differences between the two processes.
Yeah.
And that was just one. That was just one AI software that I used, but there are many AI software out there, and so if people are using that kind of information nowadays, or that kind of tool, they may get things that are erroneous and not really understand that they're different, especially since it sounds very convincing. And you can, if you click the references in the output, it's not clear, but the software is interpreting it as an authorization of that final document under HIPAA, which is not how HIPAA works.
The artificial
Yeah,
is
that's
not the intelligence.
no, that's,
no, it can make up, like, it'll make up scientific references sometimes, and it is really hard, and like I've looked up things that I know are wrong. I'm like, well, that's not, or even just about like novel. Anyway, there's a lot of AI stuff that it'll sound very convincing, but yeah, if you ask it, are you sure that's right? It'll, I thought this, and they'll be like, you're right. No, that's exactly what I mean. You're like, well, now what? Like, now I feel like you're just placating me and telling me what I want to hear.
But there are best practices to using those tools.
Yeah.
And
Yeah.
if you research that, you can improve the response of the AI tool. And if people just kind of throw questions at different AI tools, they may get very questionable answers, or I wouldn't say suspicious, erroneous answers in reality. And so every algorithm that different companies have written are based upon some data, but also rules of applying the data. And if someone understands those best practices, they can get more reliable information and more correct information than they would, or accurate than they would otherwise.
Yeah. Well, thank you. So I may propose, we also can wave goodbye to Mary Alice if you have to head out. Thank you. I may say, I will leave room for another if there's any other additional thoughts, but I was going to propose that folks potentially think about potential topics and or speakers, and we can essentially meet, you have it as an agenda item on the next meeting as like a committee of the whole, rather than have like another education outreach committee to meeting separately, just to talk as a group about kind of what a agenda and possible folks to reach out to at the next meeting. Does that sound reasonable? Dawn, was there anything else that you and Michelle want to add?
No, that's great, because to be honest with you, I don't have a Mary Bergère anymore. So just that's very helpful to have a group. And I think at the end of the day, it might be more fun, to pulling all our old past EAC members.
I think that's what we're doing with
Small.
exemptions. Yeah, it's the same we're doing
Yeah.
with exemptions, wrapping
Yes.
up the main
Yeah.
committee meeting, which I think, yeah, since there's only 4 of us, might as well. And yeah, have
Yeah.
more fun together.
Yeah, and that was a suggestion that was, you know, from Mary Alice, that if we as something that to consider if we wanted to. And I think that the role of committees is really useful when there is a smaller group to go off and do something and report back to the large group. But if we don't have a large group to report back to, it's just honestly kind of a waste of all of our time to do double meetings. And so I think identifying the actions that we can move forward with our really small group right now, it sounds like everyone is in a good place with, yeah, let's do it as a committee of the whole. So we will, if you have thoughts on that, please send them to me before next meeting. Otherwise, we can talk more at the next meeting. So unless there's any objections, I can go to the next agenda item, which is discussion of new members and appointments. We've already covered Jay and Dawn's committee hearing on Friday. I think this is a good reminder. I've been trying to harass and poke some people to apply, and I was trying to convince them that, like, you don't have to you can ask your supervisor later. You're gonna have plenty of time. Like, just apply and you can, you know, kind of deal with whether it fits with your life later when you can decide to accept or not at some point. You know, but I know when I look around, I see a gap in sort of community active members, sort of the way that Maka'ala and Robin were. I see a gap in sort of some like business people, the way like Mary Berger, and in law and the legal side of things that Onauna and others have filled over the past. So I will go and potentially talk with some former EAC members that I know / live several houses down from, and think about folks that I might be able to suggest to apply if other people can as well. I think that would be helpful. You can let me know if you're thinking about anyone that you want to suggest, or just go do it, or talk to Mary, Mary Alice. Yeah, is there anything anyone else wants to add on new members or appointments? I don't know what too much there is to say, but okay. And then just briefly, since everyone is here and it's easier than doing a whole bunch of emails, the next meeting, if we're following the first Tuesday of the month, would be May 6th at 1 o'clock. Are all of y'all available / able to block that off on your calendar so that we would have, seeing at least Michelle and Dawn nodding, so I think we would have quorum because I am as well. Okay, then let's aim for that. If there's, again, specific agenda items that are other things that come up between now and then that would be useful to talk about, please let me know. Otherwise, we'll definitely hold a place for a discussion of a sort of 343 forum. But that, again, as we talked about, that could be super, super broad. So I think some of what we talked about today, in terms of that nexus with what kinds of things 343 applies to and how court decisions and other pushes from sectors within Hawaii might, like, just directions that people are, what is the way I'm trying to say? The various directions that the application of 343 appears to be moving or could be moving. But I think it'll be helpful to think about kind of some specific topics like that, or whether that's the one thing that we, you know, focus on, or whether there's a couple different speakers that touch on different ideas. But I think the three of you actually are some of the work with 343 a lot. So if there are things that you have encountered that you think it would be interesting for someone to talk about, Jay's note on like people using AI to generate at least like initial information wouldn't hurt. And yeah, so think about that, and we'll have that as an agenda item for sure, but let me know if there's anything else that comes up. Before we adjourn, are there any other thoughts or announcements or things for the sort of good of the order, Michelle?
Yeah, I did get the DOE list on Friday, so didn't have enough time to agenda
Oh,
for this call, but we will need to do exemptions. So I know for next time we'll have that. But in the meantime, I'll read the list. I'll reach out to them with any questions as follow-up. But yeah, just want to say.
outstanding. Thank you. That's great to hear. I know we've been waiting on that for a while. Okay, we will be ready to discuss that as well at the next meeting. Unless there is anything else, I would entertain a motion to adjourn. John, motions, and Jay seconded. Thank you very much. All in favor? All right. Well, thank you all. We're adjourned at 2:18 p.m. Thank you very much.
Aloha.
Have a good afternoon, everyone.
See you all. Thank you. Thank you.